Hi, I'm Akhil Reed Amar, and I'm a professor at Yale Law School. In my chapter on precedent, I generally take the position that if the precedent is clearly wrong, you have to go with the written Constitution if the precedent is inconsistent with it. I do have a couple of moderating principles, and the Constitution I think invites these moderating principles, but once again doesn't spell everything out. I think the Constitution basically says this Constitution is supreme. But it also talks about judicial power, and part of judicial power is precedent, and it doesn't quite specify in great detail how to think about the supremacy of this text and the importance of precedent as a feature of judicial power that this text, in fact, provides. So this is a classic example of how the text actually gets us so far but doesn't get us all the way to a decision. So here's how I think about it. I say, in general, if the precedent is wrong, you have to go with the text, because otherwise you could just have a series of accumulating precedents that take us completely away from the core commitments of this, and that can't be right. On the other hand, judicial power has always been understood as retrospective. It's applying to things that have already happened in the world, and one feature of adjudication for more than 200 years, a feature that was true even before the Constitution was adopted, is that courts, especially courts of equity, and the document talks about cases in law and equity, can take account of legitimate reliance interests. The parties have relied in certain ways on certain previous statements of the law. And if they've organized their lives in certain ways around certain statements of the law, then those aren't lightly undone by judges. And so one important feature of Brown versus Board of Education, someone might remind you, is it didn't come out of the blue. Plessy basically blessed apartheid, and apartheid grew and grew and grew. It metastasized. But then beginning in the early 20th century, some would say 1914, others would say 1938, but for at least 15 years, a decade and a half before Brown, the Supreme Court was signaling its uneasiness with Plessy. It was beginning to cut back increasingly on Plessy, insisting with ever greater strictness that separate but equal really had to be actually equal, and eventually, in effect, signaling that it's almost never equal. If when we look close, we're not finding equality. And if case after case after case, beginning especially in 1938, we don't find equality, we are signaling to society, to Southern society, to apartheid society, that the days of Plessy are numbered. You can no longer rely on Plessy to organize your affairs as you once did. So Brown doesn't just come as a bolt from the blue. It actually is attentive to actual reliance interests that had been built up, in part because of the court's own mistake in Plessy versus Ferguson. So one important feature of adjudication is respect for reliance interests. Now, I say there's a second reason for going with an incorrect precedent. The second reason is if it's been blessed by the people themselves, especially if a precedent announced a new right too early, and then the people really start to celebrate that right. Well, maybe even if the case was wrong when it was decided, because it wasn't a right of the people when the first decision came down, but perhaps because of the decision itself, it has become a right of the people, ordinary people, and that's consistent with this broader theme that we've been talking about. More rights are sometimes okay, but not less rights. Plessy offered less rights, and that's not okay, and Brown eventually corrected it. Other cases, arguably they announced rights a little too early. You could think Miranda was one of those things. But Miranda today has been fairly widely embraced by our culture, and so when the court had the chance to overrule Miranda, it didn't. The opinion was written by one of Miranda's bigger critics, William Rehnquist, who at that time was Chief Justice, and he actually said, gee, even if Miranda was wrong, it was decided, it's now basically become part of the fabric. It's celebrated by ordinary Americans. It's become a right of the people. I think the two limiting principles, which we've talked about before, would be the unwritten Constitution should never undo the written. It has to fit with the written. It supplements but never supplants. And where the written Constitution is clear, it generally trumps. Relatedly, the written Constitution itself says more rights are okay but not less. And so those are two really important limiting principles, that the unwritten Constitution actually has to fit with the written in a way, often be invited by the written, even though the written doesn't fully specify the contours of the unwritten. And the written itself, in the 9th Amendment and the 14th Amendment, says more rights are okay, but not less.